this episode, we're going to look at the rights of the accused. Now, at the core of our justice system is the idea that you have the presumption of innocence. And that's the idea that a person isn't innocent until they're proven guilty in a court of law. In our legal system, the burden of guilt lies on the prosecution. What that means is that if a person is arrested on criminal charges, it's not up to that person to prove they're innocent. It's up to the government to prove that person is guilty. In the Constitution itself, Article 1, it lays out three basic protections when it comes to the legal system. The three protections that are listed in the actual Constitution itself are the writ of habeas corpus. What that means is that all prisoners must be brought before the court and told what charges they are facing. They can't just lock you up in prison with no reason. The writ of habeas corpus, though, can be suspended in times of war. In 8th grade, you will see during the Civil War, that's exactly what Abraham Lincoln does. People who are rebelling against the country during the war are literally locked up, and they're not given any kind of hearing or trial until the end of the war. Next up is a bill of attainder. What this is that you're not allowed to pass any laws that would punish people without a trial or fair hearing. And then lastly, we have the ex post facto laws. These aren't allowed either. An ex post facto law would be a law that punishes people for actions committed before the law was even passed. So these three are simple, basic legal rights that are spelled out in the Constitution itself. Now, the rest of the legal rights, or the rights of the accused, are spelled out in the Bill of Rights. So first up, we have the Fourth Amendment. The Fourth Amendment protects against unreasonable search and seizures. It basically means that the police have to have a court order, a search warrant, that allows them to search a home or business for evidence. Of course, there are some exceptions to this rule as well. If you are pulled over and the car smells like marijuana, then they have probable cause to search the car. They don't need a warrant. Likewise, if you have something laying in your yard, let's say you stole a car and you're stupid enough to park it in your driveway, they don't have to have a warrant if the car is sitting right there. That's evidence itself. It's a clear sight. So they would not need a search warrant in those cases. But the Supreme Court has said in Matt versus Ohio that if they don't have a warrant and they go into your house and they find evidence, then that evidence cannot be used in court. This is known as the exclusionary rule. Next up, we have the Fifth Amendment. And the Fifth Amendment is basically your right to due process, that we have to have a legal process with steps, and you need to follow those steps. The big part about the Fifth Amendment is that you're free from self-incrimination. So let's say you're charged with a crime and you're actually going to testify in court. You're going to get up on the stand. If the prosecution asks you a question and truthfully answering it would lead to a confession, you do not have to answer the question. You can simply say, I plead the Fifth, and not answer the question. The Fifth Amendment also protects you from double jeopardy. So you cannot be you cannot be prosecuted for the same crime more than once. What that means is, let's say you're accused of bank robbery, and you're acquitted. The jury says, no, you're innocent. The government cannot turn around and charge you for that same robbery all over again. They don't get a do-over. There's no appeal process for the prosecution, only for the person that's being accused. Lastly, you have the right to a formal hearing, what's called a grand jury, where you have an opportunity to hear and respond to charges. So you've probably seen this on a TV show where the person's in court and they're either pleading guilty or innocent, and then the trial moves on from there. Sometimes it takes months, sometimes it takes years. Important Supreme Court case that goes with the Fifth Amendment by far is Miranda versus Arizona. This lays out the precedent that suspects have to be informed of their basic rights, their rights of the accused, at the time they're arrested, and particularly their right to remain silent. They also need to be told that they have the right to counsel or a lawyer present during any interrogation. Now, let's say a person does confess to a crime. For that confession to be used, two things have to be met. So it's called the Miranda test. Was the confession voluntary? Did the person voluntarily confess to this crime? And the second part is awareness. Were they aware of their rights to remain silent? If both of those things are met and they still confess, then that confession can be used against them. So I'm sure you've heard this on TV somewhere along the line, the Miranda warnings. You know, you have the right to remain silent. Anything you say can and will be used against you in a court of law. So at the end of this rights that are explained out, the police officer has to ask you, do you understand these rights? If you say no, then they're going to have to try to re-explain everything. They also have to ask you if you would like to speak with an attorney. And if you say yes, the process stops until the attorney gets there. Next is, do you wish to speak with us now? So if you don't want an attorney, you can start talking to the police officers and they can start questioning you. Okay, there are some offspring or cases that are related to Miranda. The important one is Edwards versus Arizona. And in this one, basically what is established, the precedent that is established, is that once a suspect says they want a lawyer, then the questioning stops. You can't be in the interrogation room, and as soon as you say, I want a lawyer, the police have to stop asking their questions until the lawyer arrives. Okay, also, what's a no-no amongst police officers, and will get things thrown out of court, is called entrapment. And this was established as a precedent with Sherman versus the United States. And in it, basically, if you are kind of tricked into committing a crime, and the person who tricks you or convinces you to do it is a police officer because they want to arrest you, then that's called entrapment. And what really has to be established is, would you have done the activity? Would you have committed that crime if the police officer hadn't suggested it? So think of it this way. If the undercover police officer is a drug dealer, if you're just walking down the street and they come up to you and say, hey, you want to buy some drugs? And you're like, yeah, sure. That's entrapment. On the flip side, if they're just standing there looking like a drug dealer and you walk up to them and ask them, then that's not entrapment. So that's an example of what that means. Okay, next up is the Sixth Amendment. And this has several different rights that protect accused people here in America. The big one in the Sixth Amendment is your right to counsel, or your right to have an attorney, a lawyer. It's also your right to a speedy public trial by a jury of your peers. So the jury has to be made up of normal people. You also get a formal hearing where you have an opportunity to hear and respond to charges. You have the opportunity to confront and cross-examine your accusers. So if you've seen, one of those legal TV shows, the cross-examination is when the defense lawyer gets up and tries to poke holes in a witness's testimony. Next up, we have the opportunity to present evidence in your own behalf. So once the prosecution has presented its case, then the defense gets to present their case. The key Sixth Amendment Supreme Court case is Gideon versus Wainwright. And what is established as precedent with this Supreme Court case is the idea that if you cannot afford a lawyer, then the state is going to appoint a lawyer for you, and they're going to pick up the bill. Next up, we have the Eighth Amendment. The Eighth Amendment says that there should be no cruel and unusual punishment, and that there should be no excessive bail. So let's talk about cruel and unusual punishment. That is kind of a broad definition. So no public, whippings, no hangings in the center of town, no being locked into the stockade and left there for days on end. The other part is no excessive bail. What bail is basically a security deposit that ensures that you are going to return for trial. So your bail is set based on the crime and based on the abilities of the person. You know what I mean? So if you're accused of murder, the bail might be set at hundreds of thousands of dollars. So if you cannot afford to make bail, lots of people go to bail bondsmen. So basically you take out a loan. You would mortgage your house to the bail bondsman so that they would loan you the money to get out of jail. And if you run away, then that's where you end up with bounty hunters and that show Dog the Bounty Hunter. They're coming after you so they want their bail money back. Okay, the Eighth Amendment cases that you need to know that go with bail issues are Stacked Voices Boyle. And what this one says is a failure to appear test. They don't have to give you bail. If it looks like you are not going to be trustworthy and that you're going to take off, that you're going to fail to appear, then the judge does not have to set bail. Likewise, in U.S. versus Salerno, if you're dangerous, if you're like some crazy serial killer, they're not going to let you out on bail. You could keep going on your crazed murder spree. So those are two different examples where bail can be denied. Next up with this amendment is the idea of capital punishment, the death penalty. And is that cruel and unusual punishment? There are just a handful of countries left that allow the death penalty, and America is one of them. Here in the United States, 34 states have the death penalty. There are over 3,000 people on death row right now, right around 3,000, just under. And in 2015, 28 different convicts were executed in the U.S. The key amendments that go with the death penalty are Roper versus Simmons. And in this case, it was established that juveniles who committed the crime under the age of 17 are not allowed to be sentenced to death. Likewise, in Atkins versus Virginia, the death penalty is not suitable for somebody who is mentally retarded or if they're criminally insane. So these are cases that limit the death penalty. Last up, we have the 14th Amendment. And the 14th Amendment says that we should have equal protection under the law, that it shouldn't matter who you are, that the law should be blind. Everybody should be treated equally. Unfortunately, this doesn't always happen. We have something called jury nullification. This is when a jury sets the accused free even though the evidence suggests they're guilty. This was a huge problem during the Civil Rights era here in the South, where African Americans would be lynched and murdered, and they would find the person responsible to it, but when they were sent to the jury would be all white, and they would let the white person go who had committed the crime. So jury nullification, unfortunately, kind of shoots down the 14th Amendment. Okay, that's it for this time.